Welcome back to Face the Jury, a podcast dedicated to confronting the issues of medical malpractice in America, identifying medical malpractice, understanding it, and discussing ways for you to protect yourself and your family from becoming a victim of medical malpractice. This episode of Face the Jury is brought to you by our friends at Hughesby Reporting, the nationwide leader in court reporting, videography, and trial services. Visit Hughesby.com for more information. That's HUSEBY.com. Welcome back to Face the Jury. I am incredibly pleased to have a good friend of mine on with us today, a legendary trial lawyer from Nashville, Tennessee, Randy Kinnard. And I could literally spend the next 45 minutes just talking to Randy about his courtroom successes and professional recognitions. But I'm just going to highlight a few so you know who's with us today and what a privilege it is. Randy Kinnard is with us. He practices with the firm of Kinnard Law in Nashville, Tennessee. He's practiced over 40 years and has recovered many record-setting verdicts for injury victims, including a $22 million verdict that was the largest medical malpractice verdict in the state for a single-person incident. He's also secured a $55 million verdict in a very high-profile case involving sportscaster Erin Andrews in her lawsuit against a hotel and a stalker that was in the news. We'll talk about that. Randy was selected to the Inner Circle of Advocates in 2010, a members-only organization of about 100 lawyers, well, exactly 100 lawyers from around the country. It was my privilege to be inducted as well, which is where I met Randy. Randy has also been named the 2020 recipient of the Pursuit of Justice Award by the American Bar Association, Outstanding Trial Lawyer of the Year in Tennessee, Best Lawyers in America since 1993. And remarkably, and something that's sets Randy apart from so many trial lawyers, is that he served in Vietnam. And he was a combat airborne ranger who was awarded the Vietnamese Cross of Gallantry. He received the Purple Heart, the Bronze Star for Valor, and for Air Medal for 28 assaults in combat during his 2 tours in Vietnam. He also served with the 82nd Airborne Division and the 101st Airborne Division. And it is such a privilege, Randy, to have you here today. Thank you for taking time to join us on Face the Jury.
Well, Lord, that was quite an introduction. Thank you so much. I'd forgotten half those things.
Well, I had to abbreviate a lot. I could have gone on and on, but I appreciate you being here. Thank you so much, taking time to be with us today.
It's my pleasure and privilege, Lord. You're a great friend and a great lawyer down there in Georgia. I'm happy to be here.
Well, thank you so much. So, Rain, let's jump into it. I'm really interested in talking first about sort of your journey as a young infantry officer in Vietnam, a recent West Point graduate, how you end up from the rice paddies of Southeast Asia into the courtrooms of Tennessee and around the country. So talk to us a little bit about your journey.
That is an unusual kind of a transition, isn't it? You wouldn't expect that. I didn't expect it. I was out there in the rice paddies and the jungles, as you say, slugging it out, and never even dreamed about a legal career. I was really, being a West Point grad, kind of intent on being a career Army officer. Then I had 2 tours in Vietnam and came back and just got really bored. And part of combat is the exhilaration. You don't really want it, but it happens. You have to exhilarate. You have to really be going. And I missed that sort of exhilaration that you get.
Mm-hmm.
And I started thinking about what sort of substitute would there be for that? And somebody mentioned a courtroom work. So I started thinking about that, and I was still very bored. And so I resigned from the Army and went to law school. And back in the 70s, and I watched the Watergate hearings and all that, all those great lawyers, and became very interested in the examination of witnesses. And I thought I had something to offer clients in the courtroom, transferring those combat skills. And the nice thing about, to me, going to court was that nobody's going to die. And that was fantastic. So I've always had, because I was raised as a kind of a middle-class guy, I worked hard as a young boy. I worked in a restaurant in the kitchen starting at age 12, worked with a lot of people who just are ordinary, wonderful, sweet people, hard workers. And I developed a lot of empathy for what they go through day to day, working hard. And those are the kinds of people I normally represent. Erin Andrews was an exception. Usually it's just your ordinary good people in the street that I end up representing who've been hurt by something. And so that's, I love that idea, and that's what I did. That's how I made that transition, Lloyd.
You and I both share an interest in history, and I've read from other attorneys who served in combat, and going back as far as World War II, and they talk about the experience, as you mentioned, the exhilaration of combat, meaning your senses are heightened, your focus is solid, is unitary. I mean, you're hyper focused, and I've heard that mentioned that experience, without obviously the consequences of combat, but that experience of being in an environment where it's true conflict, and there's a true adversary, and there's a hyper focus, is as close to a replicated in the courtroom as it can be without bullets flying.
It's such an interesting parallel. The two have a lot in common, combat and courtroom. Super amounts of similar feelings. You are worried about your life in combat. You are worried that you'll die. That's a factor that you have to deal with and still get the job done. You have to overcome that. And the same thing is true in the courtroom. You have to forget your personal life. There's one thing you have to focus on while you're in there, and it is high focus, isn't it? You know what I mean? It's like, I've heard it said that in 1 week in a courtroom, a trial lawyer makes more snap judgments than the CEOs of corporations do in a year.
Interesting.
You think about that. And it's true. The snap judgments you have to make. Do I object to this question that's faulty? Is it really going to hurt? Do I look like a nuisance to the jury? All these things have to go through your mind fast, and that's like decisions you have to make in combat. Fast decisions, fast judgments.
I imagine the ability to maintain your poise and control your emotions under extremely stressful circumstances. That was a lesson I had to learn through hard work, because I typically don't have that self-restraint, or at least I didn't when I was younger. But when people are yelling at you and the judge is on you sometimes, or the opponent is needling you and attacking you, there's such a temptation to fight back, and you have to control your emotions. I imagine a lot of that is what made you successful in the military, your ability to do that.
Well, that's true. And I had a judge tell me a few years ago, Kinnard, you're the only lawyer I know when something horrible has happened in your client's case and the rug has been completely pulled out from under you. You just sit there with the little grin on your face and like nothing's happened. How do you do that? And I said, Judge, I have no idea.
A lot of practice.
Yeah, I've had the rug pulled out from under me.
Well, I don't mean it that way, but a lot of practice, a lot of trials over the years.
But that turns me to perhaps the greatest two lessons I have from combat that work in the courtroom is, don't ever let your enemies surprise you. And you should always surprise the enemy. Every chance you get, work hard at it. And I think we can do that even with discovery, where they discover everything under the sun, you're experts and everything. There's still ways to surprise your enemy. And there's nothing he can do about it, even with today's discovery.
I completely agree with that. And there's a distinction, and I know you're making it, but there's a distinction between surprising with your tactics and with your approach versus, obviously cheating or hiding things and trying to surprise with so-called ambush at trial, which I find it was not successful when it's used against me. Judges don't like it, but there is that area of creativity. I completely agree where you can outthink your opponent and let them think you're coming from one direction and you come from the other direction. And a lot of that's just preparation, as you know, and creativity.
That's right. As long as what you're doing is ethical,
of course,
that's the way to do it. And you made that distinction, and we both run into some unethical conduct, which is really hard to deal with. I mean, I recall recently in a closing argument, a lawyer putting up a slide that had case law on it. That didn't have anything to do with a jury instruction. It was horrible case law. And then the jury sees it. It's not appropriate to show that. And, you object. I go running up to the bench. And meanwhile, the defense lawyer doesn't take that down, and the jury's sitting there reading it. How you can't prepare for that except with that lawyer tell the next judge, here's what this guy is capable of doing, Your Honor. I'm sorry, but we can't have him putting case law up there during his argument.
And there's always something new, no matter how many cases you try. You think you've seen it all, and then and then something gets pulled out. One thing we have to deal with a lot is the defense trying to introduce a brand new opinion that's never been disclosed before in trial. And they'll try to slide in a new opinion. And
right.
I know you've seen that.
Oh, well, sure. We've all seen that. And it hurts when it happens. It depends on the judge, of course, who's going to instruct the jury to disregard what he just said. Or, maybe he's just broadening his prior opinion, and that's okay. So you don't know what you're going to hit. That's a good example, Lord.
Yeah, it's one I'm dealing with now in a different case. But you are a student of history. Talk about how your interest in history kind of informs your approach as a trial lawyer or benefits you as a trial lawyer.
I think like any subject that is of interest that has human elements in it, any of those that people enjoy reading about or watching on TV or maybe a movie, they give you a little more insight into humanity. What makes people think the way they do? Why do people do things they do? And it just sort of broadens your basic knowledge of people. And people are the same. Boy, my wife turned on the other night The Gilded Age on TV.
Mm-hmm.
And I don't know, maybe it's in the 1890s, somewhere in there, the story's about. And there's a lot of competition among these ladies for society, high positions in society. And I looked at my wife and I said, nothing's changed. So history helps inform us. And I think that's kind of the main way history helps me in the courtroom.
Do you bring stories to the jury? Do you talk about history? I mean, some folks invoke preachers or famous orators of the past. Do you bring in some of your thoughts about history when you're talking to juries?
Not really. I don't do that. I know a lot of lawyers like to read poetry, and for some reason, I've never been able to do that. But I will come with a short quip. If we've had a defense person not telling the truth, I might quote Mark Twain, who said, always tell the truth. That way you don't have to remember what you said. And that guy had a trouble following Mark Twain's advice.
I thought you were going to quote Twain's comment about how a lie makes it halfway around the world while the truth is still putting its shoes on in the morning.
That's a good one.
I may have butchered that a little bit, but that stuck with me too.
Yeah, that's good.
You have a reputation, obviously, as an excellent trial lawyer in all kinds of personal injury cases. I believe you've got a fairly general PI practice that ranges from motor vehicle to really the focus of this podcast, which is medical malpractice. And I've had the privilege of working with you on a case that you had here in Georgia, and you got a very successful resolution of that. I enjoyed working with you and your team. But I'd like to talk to you about, how do you do medical malpractice cases successfully in Tennessee, which is one of the toughest states for patients injured in medical malpractice, with the caps and the very conservative or difficult laws affecting the rights of people who are injured. You talk to us about how you're successful in Tennessee in a very challenging area, no matter where you are.
Well, I did enjoy that case we had together, Lloyd. Thank you for helping out down there and driving that thing. Really, I was more of an advisor on that. But Tennessee is a really rough state for medical malpractice. My experience has been that, and this is true in a lot of states, if it's close on the question of negligence, especially with a doctor, the odds are very much against the plaintiff, the patient. Very much so. I've found that jurors give the benefit of the doubt to the doctor. Sometimes I've not actually had this happen yet. It's just a matter of time. But sometimes in Tennessee, a jury that will get a few questions from the judge to answer on the form, the verdict form. And the first question is always, was the defendant doctor negligent or somehow expressed in other ways? Did he violate the standard of care or whatever? I've actually seen verdict forms and the jury answers yes. And then the next question is, did the doctor cause the injuries? Yes or no? If you answer no, your job is over. And they've said no. Interviews with those jurors say, we thought the doctor was terrible, did a terrible job, was awful. But we just didn't want to brand him for life by answering question 2, yes. And so some poor plaintiff has lost a big case, deserving compensation, because the jury felt we'll brand him for life. But we told him in this instance, you did bad. And it's a moral victory for the patient. Oh, no. Oh, that happened in Tennessee.
Yeah, that hurts.
Yeah, that hurts a lot.
That hurts.
And so it's a conservative state, and that's not all bad, but you don't have the wild verdicts like you do in other states that are more liberal. Maybe in the long run, that's okay. But if you have a good case in Tennessee, my experience is the jury will do right by the patient.
All that rings very true. I've seen cases in rural parts of Georgia, which are probably a lot closer to Tennessee, particularly up in the mountains. And for whatever reason, people up there seem more conservative, definitely more conservative than Metro Atlanta and some of our bigger cities. But there's a sense of protection sometimes of medical professionals. I think that's changing from where it has been. I think since these big healthcare companies are gobbling up more and more small practices, that patients don't seem to identify their doctor. They identify these health groups that can't see them very quickly, or treat them very, very dismissively sometimes because of the urgencies of the practice. And so things may be changing. I think they've changed a little bit in Georgia. We've had some good verdicts up in the mountains, but I completely agree. If they feel protective over their doctors, they're just not motivated to help a patient.
That's true, and it's something I've observed. If you take a small town of 5,000 people, one doctor in town, what an uphill battle that's going to be. I mean, if he's a decent person or she's a decent person, part of the juror thinking becomes, will this drive our doctor out of town if we find against him? Those sorts of thoughts are natural. And so you have to decide, going into a rural area, what are the chances really of a verdict here in this county against this doctor? It's got to be really pretty tough conduct by the doctor to justify that. It's tough.
I want to take a moment and talk about a vital partner to Bell Law Firm, which is our court reporting service, Hughesby Court Reporters and Videography Services. I have been using Hughesby for probably a decade now, and I've just got to tell you, they have been an essential partner in helping us get prepared for trial, helping make sure that we have the deposition transcripts that are done accurately and quickly. They're incredibly versatile, and they have connections throughout the country. A lot of times we travel for our depositions and have to find court reporters from around the country and remote locations. Hughesby has a tremendous network of other court reporting agencies that they work closely with. But the important thing is that the Hughesby quality control is always there. So even if we're using a court reporter from the middle of the country in a small town, Hughesby helps us find the right partner. They get the product completed. And we have just been so pleased with their services over the years that we are a loyal client and we consider them an essential part of our team. For anybody looking for a solid, reliable court reporter at a reasonable price, you should check out Hughesby Court Reporting. That's HUSEBY.com. You took on a case of national importance that got pretty much wall-to-wall coverage involving Erin Andrews, the sportscaster, who was staying at a hotel, I believe in Tennessee. And I'll let you describe the facts, but this was a very high-profile case. You brought in our mutual friend, Bruce Burlett from Los Angeles, who's another fine attorney and a good friend. And the two of y'all kind of put together the dream team and took on what looked like a pretty tough case. I mean, a very good case against the creep who was spying on Miss Andrews, but you took on the hotel as well for their failures. And can you talk to us briefly about that and tell us about that case and how it turned out?
Well, you hit the nail on the head, Lloyd. The hotel defense figured if we get hit at all, it'll be 1% of the fault. Tennessee's it compared to Falls State.
Mm-hmm.
And but they're going to blame the predator. And this jury did blame the predator, and we told them to blame him, of course, because it wouldn't have happened if he hadn't done what he did. And they hit him with 51% of the fault and 49% on the hotel. Really briefly, the facts are that this predator was following her at different hotels, trying his best to get video of her without any clothes on.
Hmm.
And he called this hotel's home office, asked to be put in a room next to Erin Andrews on a Friday night before the Saturday college football game. And lo and behold, they did that. They denied that they actually granted his wish and that he came into the hotel and made this request in person. It got really confusing, but that was one of the main problems the hotel had, is that there was a record of his requesting to be in the room next to her. Anyway, he ended up in an alcove, and there are only 2 rooms in the alcove. His was next to hers. He can hear her leave the room. When she leaves, he runs out into the hall and takes the peephole off her door, the outside part, fixes it, drills out the center part, the working part, makes it a hollow tube, puts the contraption back on the door, and then he goes back in his room and waits for her. But now it's a hollow tube. The peeping hole is a hollow tube, which you can see right through it. Here's her get in the shower, goes back out in the hall, puts his phone camera up to the peephole, and captures her in the room without any clothes on for 4 minutes. Tries to sell it, nobody would buy it. And then he just posted it on the internet because he was mean. And when asked, why did you do that? He said, I don't know. So by the time of the trial, our computer experts said there have been 16 million hits on this video. And he said, I can't tell you how many fraternity boys were sitting around one room when one hit happened. But I know 16 million individual hits. So her damage was all emotional, and she was true, legitimate about her emotional damage. I'll never forget her father testifying that when this happened, she learned about it on the internet. She called her father, and he said she was crying so hard, I thought she'd been in a wreck. Couldn't get her to tell me for 2 minutes what had happened. She was so upset. So the insurance carrier at mediation at 5 o'clock in the afternoon finally got to $1 million. And the mediator, who was a man in his 70s, made a mistake and said to Erin, I would let them take video of me without any clothes on and post it on the internet for $1 million.
Oh, my Lord.
And Erin looked at me and said, Randy, can we leave? And I said, we can and we are.
I think that mediator is a little bit lacking in emotional intelligence in that circumstance.
What would ever possess me to say something like that? But he did. So anyway, they were very shocked at the verdict.
Well, it's a tremendous verdict, and I think about I've read a lot about it, and I've read a lot about Erin Andrews' journey to get to where she was, sort of the pinnacle of this field that's not known for many women sportscasters. I mean, she's sort of trailblazer in that regard, and to have some creep, invade her privacy like that. I mean, that's just a wonderful verdict, and hopefully, I know it's had an impact because after that verdict came down, I've noticed in most of the hotels I stay in now have a metal peephole protector to help protect people's privacy.
That's something else she changed, was when you check into a hotel or motel now, especially hotels, they give you a card with your room number on it.
Mm-hmm.
And they will not call your room number out loud to you. That's so nobody else can hear it. And when you're supposed to go to a private room, that was one of the things we came up with as a mantra. This is your home away from home when you're in a hotel room.
Mm-hmm.
And so there's a lot more privacy, respect for a guest than there was before Erin's case. So she's responsible for that.
And that's just a tremendous legacy because that response is one of the reasons we do what we do. In this case was Erin Andrews, but in medical malpractice cases, when we sort of shine the light on bad behavior, bad choices, you want to precipitate that response. You want there to be a response so that there's not another Erin Andrews or another injured patient, that there's a response. And we all know what motivates folks is the risk of financial consequence. And that's very true with corporations, hotel companies, hospital groups. If they think it's going to cost them more to do business as usual than fix the problem, that's a positive thing. Y'all really demonstrated that in that case.
Lord, that's exactly right. I had an obstetrician come up to me a few years ago at a party. And he said, Randy, when I get a call at 3 o'clock in the morning that a lady might be ready to deliver, do you know why I go in? I said, why? He said, you. Well, that's good.
That is good. That is good. Because, 1 out of 100 times, it's probably not a big deal. Could probably wait till the morning. But that little extra bit of motivation is good.
I took it as a compliment. I don't think he meant it as a compliment. Maybe he did.
I would take it as a compliment. You have given a presentation that I had the privilege of watching. I'm trying to remember when it was. It may have been the Inner Circle meeting last year. And the title of it was RESPECT, respect. And you've been giving this talk, I believe, to different trial groups around the country. I read somewhere that your goal was to deliver it to all 50 trial lawyer associations around the country. I'm not going to ask you how that endeavor's going. That's a big undertaking. But first of all, tell us what that presentation, what motivated you to develop that sort of lecture or speech, and why you feel like it's so important to try to reach as many folks as you can.
I've traveled the country giving that speech. I think I've made it to 35 states. I doubt if I'll make all 50, but I think. But I've given it over 100 times. And even in churches, Sunday schools, I've given this speech because you can adapt it to where it's applying to non-lawyers. But the point is, I have been lucky or fortunate to show respect to my opponents in cases. And it inured to the benefit of my clients. And I've had lawyers, the way this speech came about is one lawyer said, I saw you taking it, Randy. You were getting home cooked in a rural county in Tennessee. The lawyer was on you, the judge was on you, and you just stood there and took it. Were very respectful. And you ought to give a speech about this. He said, you went on and won the case. So he said, I would have fallen apart. I would have gotten so mad. And so that's what prompted that speech in the first place, 15 years ago when I first gave it. And I talk about the benefit to you personally as a lawyer of being respectful. You sleep better at night. Your opponent will appreciate it. And you don't lose ground, in my view, from being respectful. It's not being weak. It's actually takes strength to do it sometimes when you might want to otherwise not be respectful. And back in the earlier days in my practice, I was not so respectful. I'd get angry, which was a result of issues from combat. I'd get angry real easily. Ultimately, I got counseling about that and appreciated that I had an anger issue and that I had to be very careful. And I became more careful and became more respectful. It really is good for the system. Juries don't want you being disrespectful. They want to see a fair fight. They want you to fight hard. But if you can be respectful at the same time, I think you'll find that the verdicts for your clients are bigger than they would have been if you're not.
That all resonates so much. We've had such a similar, in some ways, a similar kind of emotional trajectory in trial, because I started off very, probably a little bit like you were, angrier. I heard somebody talk about this recently, that the genesis of anger is usually fear, almost primarily fear. Fear of looking weak or fear of looking like you don't know what you're doing. And when you're a young lawyer, those feelings can overwhelm, especially with an older, experienced lawyer talking down to you and make you feel really, really small, so you feel like fighting back. But it takes a lot of wisdom to appreciate what you're saying, that you're so much stronger if your emotions are in check. You're not Mr. Spock, but you're not going off and showing the other side respect, even when they don't necessarily deserve it. In juries, I'm interested in your comment about this. What I've seen is that jurors are much more willing to give a pass to bad defense conduct, huffing and puffing and misleading, all those things. But if a plaintiff's lawyer does it or even hints at it, the punishment's pretty swift. That's been my experience.
Lord, you're 100% right. In my book, I've seen the worst, what I consider really bad conduct by defense lawyers. They get away with it with winning the case. It's almost like the jury, we expected him to be like that.
Right.
But we did not expect you to be like that. You're asking for a lot for a client, and we're expecting you to be Mr. Nice Guy. Now, there are some plaintiffs' lawyers who can act belligerently and still win. I worked for a man who was like that in law school. I went to court with him and saw he was the meanest thing in the courtroom. He was like a bull in a china shop. And he'd win, but the verdicts were terribly low. And I think I learned a lesson from that, but I think you're right.
My suspicion, without any data behind this, but my suspicion when I've seen this on the defense side is that jurors kind of understand that if somebody's being accused of something, that creates a motivation to really fight back hard. And they don't really blame the defense lawyer for fighting back hard because they want somebody fighting back hard on their side. But we have to, I think, do our best to rise above that and reflect the ethos of our character, of our case and our character and our client's character. Because we act badly, the jury's going to hold it against our client a lot of times. I've seen that happen before.
Right.
So easier said than done. Easier to say on a podcast when you're in the heat of battle and people are firing at you and trying to cheat.
Well, I have one tip for lawyers that are listening or people that aren't even lawyers. If you're in a hot situation and there's maybe an argument going on at home in the kitchen, or some defense lawyers taking advantage of you in the courtroom or at a deposition, here's 2 tips I can give. First thing you have to do is stop, is pause. Very hard to do. Like if you're in a fight, you don't just stop. You want to keep slugging it out, right?
Right.
Keep pounding back. But if you can pause 5 or 6 seconds and take some deep breaths, and then you can start thinking better about the situation. If you do not pause, it's very difficult to think clearly and to act respectfully. But just pause. There's nothing wrong with it. And when you do that, the other person takes notice. He goes, I don't know how he or she just did that.
Mm-hmm.
And it gets their attention. And I think that's about the best 2 tips I could give you. Pause and breathe. That's the best tips I could give somebody else.
That's great advice. And the other, it makes me think about in the heat of the moment with the judge, when they're pressing you to take a position, and it can make a huge difference in the case, on appeal or whatever. What's your position? Almost always, if I'm not absolutely clear what my position is, I'll say, well, can I just take a moment? Your Honor, there's an important issue. Can we just take 5 minutes? Let me talk to my co-counsel. Let me talk to my client. Let me just get back to you in just a moment. Most of the time, the judge will let you do that if it's an important issue.
That's a great point, Lloyd. That's fantastic. I don't know a judge that would disrespect you and say, no, I want an answer right now. Particularly if there's a record.
Well, that's right. And it's also cumulative, what you're talking about earlier about respect, that if the judge has seen your conduct in the entire trial and how you treat the opponent, your opponent, you're not turning to them in court and arguing directly with them, you're maintaining decorum, the judge is more likely to give you that accommodation and return the respect. We're all human beings. This is a human endeavor. People are more likely to treat you with respect if you show it to them.
Excellent point.
So it's funny. I remember I was been preparing for this podcast today and looking forward to it. I was trying to reflect on how I first met you. And I think I first met you in the gym. I had somehow managed my way down to the gym one morning on one of the Inner Circle conferences. And there you were just going at it on the treadmill and whatever time it was, 6:30, 7 in the morning. And we spoke and met each other in the gym. And then I was like, he's got a few years on me. I don't have any excuse for not making it back here the next morning. And I saw you the next morning. I'm like, God, if I don't show up the third morning, Randy's going to get on me and say, you're getting lazy. So you can have influence on people beyond the obvious. And now I generally try to get to the gym at these meetings.
Well, you're staying in shape, Lloyd. I think that's important. And I am older, so I have to work out 6 days a week to keep up with you young guys. So,
well, I suspect it's a lifetime habit that you formed, which is such an important thing. We had a podcast talking about all the ways that trial lawyers strategies to stay healthy, and especially when you're in a 3-week trial as far as diet and those kinds of things.
Yeah.
Let me ask you this, Randy. So, and we're going to wrap up here in just a little bit, but reflecting back on a lengthy career, one that's still being developed, but you're looking back over the 40 years of trials and courtrooms. What would you talk to the younger lawyers about that we haven't already discussed in terms of how to be successful in this area, which is so competitive and high stakes, where people's lives really are affected? What advice do you give the younger generation coming up?
Well, number one, always be respectful to your potential client that comes in, to everybody, the witnesses, the judge, your opponent. There needs to be, I believe, a burning desire inside you to help people. And if you have that, you're going to be a success, assuming you work hard. And I think trial lawyers work very hard, by the way. But you work hard, be respectful, have that burning desire to help your client, and you will figure out what to do with each client. And the word will go out about you if you're a brand new lawyer. It's going to go out. Other lawyers talk about younger lawyers. What kind of impression does that older lawyer have of me? And that's very important. I think that's the essence of it. Just have that burning desire, follow your heart, go for it, and always be respectful. And good things will happen to you. Bad things are going to happen to you. But know that, and then just pick yourself up and keep charging.
Advice, Randy. And it's been such a pleasure talking to you today. I know you've got a million things to do, and it's a real privilege that you've taken time out to be with us and share some of your wisdom and insights.
Gosh, thank you for asking me to do this. It was fun. I said it at the beginning. You're a great lawyer, a great friend, and I've enjoyed talking with you, and I hope the listeners get something out of this.
Well, thank you so much, Randy.